Something that all of us, regardless of what our business senses are, ought to do always is what's the liquid assets, what's the liquid position of the trust? If you're going to be involved in a substantial litigation against a downtown Los Angeles law firm who will remain unnamed but was unfortunately named in a particular case called Donahue where there were $5 million of fees at risk, if you're going to be defending that kind of lawsuit or involved in that against those kinds of resources, and your trust estate may be worth $30 million, $500,000 in cash and $29,500,000 in real estate in Nevada, someplace like, you're going to have a real problem in terms of managing the litigation. Do you want to be your client's banker? And I frankly don't. So that when you're presented with that kind of problem, then part of your advice to the client, to the trustee, is how can you create liquidity to create a war chest? I think that's it's a business concern, but it's certainly reasonable for you to discuss that with the trustee and reasonable for the trustee to think about. So now let's say we've gotten beyond those strategic concerns and now we want to create or modify the agreement. And when we get paid, obviously, if we're representing the trustee, the first thing we want to do is avoid court scrutiny for the reasons I've alluded to. Nevertheless, we should always prepare for court scrutiny because, unfortunately, in trust litigation, attorney's fees often become the tail that wags the dog. And it is a real problem if you haven't considered in advance what your fees, how are you going to present your fees, because especially when you get down to the negotiation and the mediation, close to the end is, we were saying that more than 90% of cases settle in some kind of negotiated framework. When that happens, you don't want the attorney's fees to be an obstacle to settlement, and you don't want to be in a position that you don't know what the attorney's fees situation is. So you want to prepare from the outset. You want to remember that there is a reasonableness standard in terms of attorney's fees, that the code applies, that the court will apply, and the problem is that we all have different definitions of reasonable. There is a 3-year statute. So if there's a trust administration that's turned into litigation, if there haven't been accounts provided, or the accounts have been provided and it has been more than 3 years, then at least those fees are off the table. But if it's within the 3-year period or no accounts have been provided, all of the fees paid are going to be an item of negotiation and the subject of dispute. And remember that if you're in court defending your fees as the trustee's lawyer, the court and the beneficiaries are looking at it from a hindsight perspective. And yet you have entered into this arrangement with your client and you are defending or representing your client on a foresight basis. We don't know what's going to happen next week. But we do know that when we go to court, the judge is going to say you should not have spent the 100 hours you spent that week preparing that motion or doing whatever it was you did. So really, you have to be thinking down at least 3 miles down the road when you are doing trust litigation from an attorney's fees point of view.